Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We had been for quite some time reporting on the Idaho 4 defamation case, Scofield versus Guilard. This was a civil lawsuit for money damages. It involved a 2-count complaint for defamation of character brought by the plaintiff, Scofield, a University of Idaho professor at the Moscow campus, who sued an online content creator, tarot card reader, and psychic, Ashley Guilard, alleging that she had been defamed by Guillard's public statements. She had involvement in the catastrophic events that occurred at 1122 King Road on November 13th, 2022, that resulted in the tragic loss of 4 University of Idaho students. That case progressed through jury trial the last week of February 2026, when the jury returned a $10 million verdict in favor of Scofield. The judge entered a final judgment shortly thereafter for $10 million against Ms. Guilard. We previously reported that Ms. Guilard, who has been acting pro se in this case, meaning she's acting as her own attorney as well as a party, filed an appeal to the Ninth Circuit Court of Appeal, the appellate court over the district court in Idaho, federal court, where this action proceeded to its conclusion. There has been a schedule that the appellate court put out in case number 262190, which will be Guilard as the petitioner versus Scofield as the respondent. The pleadings, the briefings in that case have not yet been filed. They are to be filed later this year pursuant to a schedule that the Ninth Circuit Court of Appeal has set. When briefings are due appears April 9th, 2026 on the district court docket. It's item number 157. There was a second action that Ms. Guilard has filed in the district court in an effort to get this judgment thrown out. It is a motion to set aside the final judgment. She filed it on the 6th of April. She's raising, amongst other matters, fraud. She had raised this issue of alleged fraud even before the jury trial of this action, when she tried to get the case dismissed. And in the alternative, if the case was not dismissed, the right to file an interlocutory appeal at that time before jury trial to the Ninth Circuit Court of Appeal. The district court judge, Patricio, who presided over the case, denied both. The response to that motion to set aside the final judgment was filed this past week by Scofield. It raises both procedural and substantive reasons why the court should deny the motion to set aside the final judgment. It is dated April 27th, 2026. It is document number 160. What the plaintiff has raised is that this motion to set aside the final judgment was tardy. It violated the applicable federal rule of civil procedure as to when such a motion needed to be filed. She's alleging also substantive grounds why the judgment should not be disturbed. We are awaiting at this time Ms. Guillard's reply to that response, which is due on May 11th, 2026. Thereafter, we're anticipating a ruling by the judge. We will, of course, keep you posted as further developments arise regarding the second effort by Ms. Guilard to get that $10 million judgment thrown out of court. Until next time, this is Kathy. Thank you for joining us here today.